All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you very much and welcome back. Judges have some follow-up questions. We will begin with Judge Ibanez.
Thank you, Mr. President, for your floor. For the professors, will be this question. Any of you can ask or address the issue. Yesterday, we heard submissions from professors that referred to the Pinochet case. In that case, it was established, among other important findings, that if, as alleged, Senator Pinochet organized and authorized torture, he was not acting in any capacity which gives rise to immunity ratione materia, because such actions were contrary to international law. In this regard, I would also like to refer to another important extradition case, namely the Fujimori case, former president of Peru, in which it was also established that the former head of state and current vital senator at the time of the extradition proceedings did not enjoy immunity in relation to grave violations to human rights, such as torture. The question is, are the standards for arrest and surrender under the cooperation regime in the statute higher or lower than those required in the context of extradition?
Yes, Professor, or Mr. O'Keefe, as we say in the courtroom, please.
Judge Ibanez, if I could just address the premise of your first question about the Pinochet case. And with the greatest of possible respect, what you quote as the ratio of the case is not the ratio of the case. As explained subsequently by the UK House of Lords, and as revealed in the case when analysed closely, of which there were 3 to 4 separate reasons given by the respective judges, the ratio is not, with the greatest of respect, that international crimes, or indeed the specific crime of torture, can never be considered official acts, such as not to give rise to immunity ratione materiae. The ratio is rather more complicated and perhaps less convincing, but it is as follows. The Torture Convention, specifically, the Convention Against Torture, to rightly pick up on a leitmotif, I guess, of what the President said before, obliges states parties not only to provide for extraterritorial forms, indeed universal prescriptive jurisdiction over torture as defined in the Convention, but obliges them in the event that someone suspected of that crime turns up on their territory to prosecute the person, or in order to get around prosecuting the person, to relieve themselves of that obligation, as the international court said in Belgium and Senegal, to hand the person over to another state party that will. The court, the House of Lords, also pointed out that the definition of torture in Article 1.1 of the Torture Convention is such that someone accused of torture must have been acting in an official capacity at the time, or at the very least under the cloak of someone else's official capacity. So what the House of Lords said is this: you have a crime defined in such a way that only those who would otherwise be able to rely on immunity ratione materiae commit it. On the other hand, you have a convention obliging states to assert universal jurisdiction over and to prosecute such persons. The two can't go together. So this inconsistency within the Torture Convention itself, they resolved by saying, well then, the parties must not have intended or envisaged that immunity would be available ratione materiae, specifically in relation to the crime of torture as provided for and prosecuted under the Torture Convention. And as later said by the very same House of Lords in the case of Jones and the Ministry of the Interior of the Kingdom of Saudi Arabia, it was not the ratio that these things cannot be official acts such as to enjoy immunity. Indeed, the court pointed out that is an absurd reading because torture is defined as an official act. That is the first thing I would say. The second thing I would say is all of that is immunity ratione materiae. And as they said in the Pinochet case, if he had still been the head of state, there is no question but that he would have enjoyed immunity from the extradition proceedings before them. So I would just challenge that particular point.
On grounds of what?
I beg your pardon? On the grounds of that immunity
personae?
ratione personae has no exception in that regard, or putting it another way, is not dependent on the official capacity in which the person was acting at the time, such as to fall within their ratio based on official capacity. So I'll just address that first point. Perhaps others can address the Fujimori point with your permission.
Before you said on that, just to follow up, when you spoke earlier, you spoke about an altered rationale, so to speak, for immunity ratione personae.
Indeed.
Being to enable those who hold office to which it applies to perform their functions effectively. But the point has been raised here, I believe, and it also hangs in the air. When we say perform functions effectively, what exactly are we talking about?
Right.
When we are saying, that is the question being posed, that the head of state used office to commit genocide or crimes against humanity, is that the efficient performance of function for which immunity ratione personae should exempt someone from the legal process?
Right. Well, this is precisely what the International Court of Justice itself addressed in the arrest warrant case, in which it explicitly said a personae.
Even if they commit genocide?
Yes, yes. And the reason that the court gave is as follows. It is immaterial whether the capacity in which they are alleged to have done this was private. It is immaterial whether on some reading of what ought to be the sorts of things people do in their official capacity, that the act of genocide or the act of torture or the crimes against humanity and grave breaches in that case fell outside that. The court's point was this: if you allow prosecution or arrest while the Minister for Foreign Affairs is the Minister for Foreign Affairs, while the head of state is the foreign state, while the head of government is the foreign government, you still interfere with their performance of their functions on behalf of the state. Let me put it this way. The head of state...
Let me alter that scenario for you.
Sure.
When you have, for instance, a scenario where, and hypothetically speaking, where somebody wasn't the head of state, but somehow they manage to shoot themselves into office, perhaps committing genocide, and then there's charge against them on that basis. Would they still enjoy immunity?
Yes,
Ratione
yes.
personae?
Yes, because the point of immunity ratione personae, to use the words of a former advertisement for British Telecom, is that it's good to talk. What the court says is diplomats, the Minister for Foreign Affairs, the head of state, the head of government represent their state abroad. And therefore, putting it bluntly, we have to swallow the bitter pill and perhaps accept that there are some circumstances in which it is not at all attractive that they will enjoy immunity, but nonetheless they must in the interests of international intercourse. So the point is this: if the King of Saudi Arabia goes to London to shop at Harrods in his personal capacity and is arrested in his personal capacity, he is nonetheless incapacitated as the head of state of Saudi Arabia and therefore incapable of representing his state in the event he is called on to represent his state. Is that sufficient?
I think so. Thank you.
Thank you, Professor O'Keefe. From your answer, are you stating that immunities or immunity is an absolute concept or an absolute institution that does not have any restriction or limitation? Because in the field of right, we all know that even rights have some limitations.
Right.
How can immunity, that is a privilege, that born up from exemptions from the principle of territorial jurisdictions of the states, can be an absolute concept? Could you explain it?
Okay.
What is in your view?
Sure. Can I first go back to this notion of a privilege? It is not a privilege. It is an immunity. The conventions on privileges and immunity distinguish between privileges and immunities, but the distinction is completely technical. An immunity is an immunity from jurisdiction and would include inviolability from enforcement measures. A privilege is something like a substantive exemption from the taxation regime of the local state. Substantive. A substantive exemption from visa requirements. Immunities are procedural, but both are rights held by the state whose official it is. Now, this idea that somehow they are to be read narrowly because they constitute exceptions to the principle...
Actually, the point of the question is, however we characterize it, whether we call it a right or a privilege, we can agree for purposes of the discussion that it is a right. The point of the question is it an absolute right with no exception? That is the question.
Yes, and the answer to the question is, if you read the arrest warrant case, if you read everything said so far by the International Law Commission in relation to immunity ratione personae, if you read states' reactions to that in the 6th Committee of the General Assembly, and if you read every single domestic court judgment, you find it is, while that person is in office, absolute. Now, some people say, but the French call the cassation in the case in relation to President Gaddafi mentioned the exception. They said, this does not fall within one of the exceptions of the immunity of a head of state. The exceptions of immunity of a head of state are in the civil sphere. In the civil sphere, just as with diplomats, there are some extraordinarily narrow exceptions to the otherwise absolute immunity ratione personae of these people in relation to, let's say, a diplomat accredited to the Court of St. James in London starts dealing speculative in real estate if he were or she were to be sued for damages, then that is an exception from civil proceedings. But there are no exceptions, as the International Court, the International Law Commission, and the unwavering practice of states tells us, to immunity ratione personae. The only state that tried this, Belgium, ended up in the International Court of Justice, lost, and its own Cour de Cassation said that it had violated international law. It may sound unpleasant, and as my colleague and friend, Professor Robinson, said, there are no doubt very uncomfortable issues raised by this. But the answer, as states have agreed, seems not to be to take away the immunity. The answer seems to be, as the International Court of Justice said in paragraph 61 of the arrest warrant case, waiver, wait till they're gone, put them before an international court whose statute specifically relates to this question and takes away immunity.
Thank you very much. Professor Kress wanted to respond to the question or the discussion so far.
Thank you, Mr. President. Might I make one comment on the answer just given by my distinguished colleague and friend Roger O'Keefe, and then turn to the last bit of your question, Your Honor. It is true, and I don't think anybody has disputed that immunity ratione personae in national proceedings is absolute. I certainly have not disagreed with it. In my written observations, I have made that crystal clear. The ICJ was crystal clear, and I accept that as a matter of customary international law. However, the ICJ has gone further in one very important paragraph, 61, and has said the matter is different explicitly when it comes to proceedings before certain international criminal courts, including the ICC. This is the issue. And the key question is not whether immunity ratione personae is absolute there where it has to apply in national proceedings. The question before that chamber is whether we are confronted here with an issue of national proceedings or international proceedings.
And the question there, the issue, it seems, sometimes we, in both the written matter and the discussion, we may forget that nuance. The issue is whether what is said in paragraph 61 of the arrest warrant case relating to international court, whether that kind of exemption, if we call it that, can be dragged into the national realms when there is a request for arrest of somebody so the person can be tried at an international court, which is not the issue before the ICJ in the arrest warrant case. In the arrest warrant case, it's purely a matter of the Belgian court exercising jurisdiction over international crimes. But here it is, can we drag that into an ICC scenario like where we are now?
I would agree just with this one qualification. You said in the national realm. If I understood you correctly, here I would make an important qualification. That's just the question as a matter of law, national, jurisdiction, or international. That's the issue on which we have spoken. And I will take the opportunity to elaborate a little bit on this issue on the basis of the last part of your question, if I understood Your Honor correctly. And the last bit seemed to be, is there a difference between interstate extradition proceedings and the vertical cooperationship between a state party and the ICC? And that's a crucial question because it is at the heart of the issue. And I would argue respectfully that there is a difference, a crucial difference. And let me just respond to one important and very helpful consideration, again, by my distinguished colleague and friend Roger O'Keefe, who draw the attention of judges to the European arrest warrant scenario, saying that perhaps the court should draw an analogy from there. And I would only answer to this with a degree of caution. The European arrest warrant system at first glance may seem similar. But if you look closer to it, it is far more similar to a traditional interstate cooperation level than to the level of
Ms. Rokier,
vertical
can you turn off your microphone, please?
Sorry.
Thank you.
To the system of vertical cooperation we will here. I will make it very clear, I try to make it very clear to your honors under what conditions the analogy would hold. The analogy with the European arrest warrant system would hold if there would be a system of crimes under European law with a European Court of Justice to adjudicate those crimes, and most importantly, with an established European court immunity exception parallel to the one I have yesterday explained to you, which has come into existence under customary international law. And then under such a system of vertical cooperation between this hypothetical European Court of Justice and European member states. This would be a correct analogy. And if this were the case, Your Honors, I would not hesitate a second to apply the same reasoning I have presented respectfully to you yesterday to this scenario. But I think it is obvious that the European arrest warrant system as it exists today has little to do with the hypothesis I've just explained. Thank you.
Thank you very much. Yes, Mr. Raston.
Your Honor, may I ask, on the topic of the European arrest warrant, I also wanted to make some observations, and if this is an appropriate time.
Please proceed.
Yes, I just wanted to follow up on the point that Professor Kress has made. It is an interesting analogy that Professor O'Keefe points to, but of course, the European arrest warrant framework is fundamentally an interstate framework. It basically builds on existing extradition practice. So it is quite different from the surrender process. You will recall that the statute, of course, makes a distinction between arrest and surrender processes and extradition. So, for example, in the European arrest warrant, we see in Articles 3 and 4 of it that states retain the traditional exceptions to granting extradition, which include the principle of double criminality, which doesn't apply here, statute of limitations, doesn't apply here, amnesties, not clear, applies here, it's currently in dispute in some cases at the first instance, as well as respecting decisions not to proceed without exposing them to a genuineness assessment, again, doesn't apply here. The only thing that the warrant, the framework decision provides is for a mutual recognition framework, which is the analogy perhaps to what Professor O'Keefe was saying, but that's again based upon the consent of the relevant states to implement that system. And then the express reference to observing the privileges and immunities that might apply in relation to Article 20 of the framework decision, again, is something that states have expressly chosen to confirm, whereas in Article 98 we say the drafting history, and I think we did deal with the drafting history, doesn't show itself to be definitive. So just turning to the question asked now, we absolutely agree, and we also, I think we're on common ground that, of course, personal immunities.
With who?
With everybody here, in terms of the scope of personal immunities, yes, of course, at the national level, it applies to, it is without exception. And the ILC, indeed, in its adopted conclusions, which it has transmitted and finalized recently, recalls that. So we're not disputing that either. But we are, similarly, as Professor Kress has just noted, trying to understand the relevance of that to proceedings before this court. And what we fear is that the way that the matter has been approached by, well, Professor O'Keefe this morning, or AU and LAS and Jordan Council earlier, appears to conflate these two essential processes, the national and the international, it would be as if creating a catch-22 situation where the ICC is distinguishable from national criminal jurisdictions. It's there actually set up to be a complementary mechanism that would replace the inability or the unwillingness of states to operate, including in these kinds of contexts, as one of the key contexts in which the ICC operates, distinguishable from national jurisdictions, is in relation to the irrelevance of official capacity. States are mandated to enforce the orders of the ICC because the ICC doesn't have its own enforcement limbs. But then the very process of enforcing it smothers the ICC's exercise of jurisdiction into national rules and customary international rules that apply at the interstate level. So that would create an illogical outcome in a circumstance where, while that assertion could well be made, we don't see the evidence for it. So in terms of where does the evidence, what burden lie? Well, even if it lied with us, we have given examples of inconsistent state practice and opinion jurists to show that we can't see that this matter is settled, that this necessary analogy between national immunity rules is directly transferable to the ICC. We say at best this question remains unsettled, and certainly the result of that is that you have to then go back to special international law, which is the applicable treaty regime, and that engages into the discussions that we will grapple with tomorrow.
During the first, I believe, iteration of the ILC in 1947 or thereabouts, I think it was Monsieur Henri Donadieu de Vabre, who was a French judge at the Nuremberg Tribunal at the time, who urged the creation of an international criminal court because he observed, say, that when they were in Nuremberg, they were very much alive to the complaint that it was, according to him, not me, a victor's court. A victor's court. So the creation of an international criminal court makes a difference. So it will remove that kind of suspicion, and that would be something you would agree with, isn't it?
Yes, I mean, the reason that in our submissions yesterday I said that the phenomena of a national execution of an ICC warrant really begins from the 1990s onwards is because, and here I agree with Professor Robinson, what happened after World War II, it is quite unique. There is indeed no question of national enforcement of an international warrant. The Allied countries were in occupation, were in total control, and had the ability to exercise all powers within the relevant states. So the issue did not arise in the same way. I think it only arises possibly at the ICTY and then expressly and the ICTR and then with the ICC statute.
All right, thank you very much. Yes, please, madam.
Seulement deux petits points, ou peut-être trois. Je voudrais revenir sur ce que M. O'Keefe a dit à propos de la question de la torture. Il faut se rappeler qu'on prévoit là la juridiction universelle relative, mais quand même juridiction universelle sur la base de 4 critères de juridiction pour des faits qui sont commis par un agent d'État. Parce que la Convention de 1984 concerne seulement celle qui est appelée de façon un peu synthétique mais expressive la torture d'État. Après, je voulais aussi souligner que quand même, à propos de ce que justement le professeur Kress a dit, une chose, c'est les juridictions nationales et l'immunité, que ce soit seulement en ce qui concerne la juridiction de cognition, la juridiction d'exécution, par rapport aux juridictions nationales. Toute autre chose, c'est le système de la Cour pénale internationale qui est un système de transfert de pouvoir dans le champ, dans la matière pénale, de transfert de leurs compétences par les États, de leurs compétences à la Cour pénale internationale. Donc, c'est un système de limitation de la souveraineté dans la matière pénale des États. Et ce système est en plus, dans le cas d'espèce qu'on est en train de discuter ici, renforcé par la résolution du Conseil de sécurité qui est rendue sur la base aussi de pouvoirs de limitation de la souveraineté des États membres. Et pour conclure, aussi cette question de l'analogie entre le mandat d'arrêt européen et le mandat d'arrêt, et en particulier la demande d'arrêt et de demande de remise de la Cour pénale internationale. Ce sont des systèmes qui fonctionnent de façon tout à fait différente. Comme déjà on a dit, dans un système, le mandat européen, c'est encore le système de rapport interétatique. Tandis que dans le système de la Cour pénale internationale, c'est une question de limitation de la souveraineté des États de juger et de rendre des mandats d'arrêt et de remise d'un accusé. Merci.
Thank you very much. In order to cover as much ground and interests as possible, I will give the floor to my colleague, Judge Hofmansky.
Yeah. Hello. Thank you very much, Mr. President. I have two questions. One is related, is basically a question which is procedural in its nature. We all agree that there is a complicated legal question before us. The Council of the Hashemite Kingdom of Jordan argues that the pre-trial chamber has already determined that Mr. al-Bashir enjoys the immunity, and therefore, if the appeal chamber would deal with this problem, the scope of grounds of appeal would be exceeded. I would be happy to hear the reaction of the prosecutor council related to this matter. And this is the first question.
Your Honour, I was actually going to touch on this point when I come to my submissions in Group B, but I can definitely do so now.
1 second, then. 1 second.
No, it's not.
In that case, why don't we wait until...
I don't mind dealing
you're
with it
going
now
to-
because it's not strictly about B. I mean, I can easily deal with the point.
Okay, if you can do that then very
Sure.
quickly, because we also, I understand Council for the African Union would also like to
Sure.
say something on the first question.
I think it's important to put what our view is on the matter as to how this court should approach the decision of the court below. So in our view, the appeals chamber should follow and uphold, obviously, the pretrial chamber's reasoning in the Jordan decision. And we'll show you this afternoon that it's the legally most convincing one, but also as a matter of best appellate practice and because of judicial economy, which has also been raised, and because it's in accordance with Article 83(2) of the statute. Why do I say that? It is the ratio of the decision. That's clear. And also, it is within the four corners, we could say, or the three grounds of the appeal to do so. But I want to make a point, and it relates to Article 83(2). Your task as an appellate chamber is obviously to decide whether, under Article 83 if there's an error of law which materially affects the decision. So if you agree with the decision and you agree with the reasoning, as we've said in the brief, our suggestion is that you can and should stop there. But if you agree with the decision, but on a different reasoning, if you agree with the decision, but for different reasoning, you can go there and you would not be necessarily bound by every argument in the appeal. And that's because the question before you is whether the decision was correct. There could be an alternative basis for why that decision is correct, and you could go there. And also, you could go there, even if you uphold the decision, you agree with the reasoning, but you find there are alternative bases, additional reasoning that you could give to support that reasoning. Thank you.
Thank you very much. I must reflect for the record that Ambassador Namira Negm has joined the court for the record. She was not there in the morning as counsel for the African Union. Now, the African Union would like to make some response, and then Jordan as well, please. Mr. Gladin, quickly.
Thank you very much, Mr. President. In response to the first group of questions, we went back to this question of yesterday as to whether or not the rule is somehow different when the immunity involves a person who is sought by an arrest warrant. And again, we seem to be going back to paragraph 61 of the arrest warrant case. It's important to emphasize, again, that paragraph 61 of the arrest warrant case speaks about the exercise of jurisdiction by an international court. It is not the exercise of jurisdiction by a national court in relation to proceedings before an international court. That's a reading in that's not there. We were also offered some practice. The one example of practice, for example, was the Milosevic case. But there are a couple of things that make that inapplicable here. One, he was arrested by his own state. Two, at the time that he was arrested, he was not a sitting head of state. But there's a third, more important reason, and that is the circumstances under which he was arrested are completely different. There was a UN Security Council resolution that explicitly, without any kind of a requirement for fictions or reading in, that explicitly obliged all members of the United Nations, and by the way, it doesn't matter if Yugoslavia was or was not a state party. The UN Security Council resolution explicitly, not implicitly, not through some fiction, explicitly obliged all UN member states to cooperate. We have been referred also to the Kenya decision. I had the opportunity again to reread that decision.
Does it make a difference that when the arrest warrant or the indictment, and the arrest warrant, I believe, of Mr. Milosevic were unveiled in public, he was a sitting head of state, but there was no protest saying, no, how you cannot do that as a sitting head of state. Does it make a difference?
Actually, it doesn't. And this is a point, of course, that Mr. Kress raised yesterday, linking the decision that there's a duty to arrest with the silence. But silence, or rather the lack of objection, is qualitatively relevant for the purposes of establishing some kind of practice or custom international law if there was, in fact, some reaction sought. Mr. Kress has not advanced a single reason why African states would react to this, a single reason why Western European states would react to this, a single reason why American states would react to this. So there was no requirement for, the circumstances did not call for a reaction, so of course they wouldn't object.
Oh, right. And you're a sitting head of state, and you see another sitting head of state being indicted. That shouldn't tell you, hang on, I may be next, so this is the time for me to say no to this thing. isn't that an invitation in itself to other heads of state to say, no, we can't allow this?
Well, no, I still don't think so. And the reason, again, is because there isn't the circumstances do not call for a reaction because, particularly with the groups of states that I've just mentioned, there is no call on them to act in any particular way. The circumstances would call for a reaction if there was, in fact, if that decision were directed to them. But the decision is not directed to them because there is no way that they could affect the rest. But in any event, the most important point was, even at the time that the decision was made, there was, of course, a UN Security Council resolution that explicitly, that overrides everything. So that in fact, even if this was real practice and you could read some kind of a practice into this, the fact is that there was a UN Security Council resolution that explicitly obligated states to cooperate, which is not the case here. We were referred to the Kenya cases. I had the opportunity to look at that case again yesterday. And it's a very interesting case because it's complicated. I won't do a full analysis of the case, but I will just say a couple of things about that case. First of all, at I think pages 41 to 42, the Supreme Court of Appeal re-emphasizes the absolute nature of immunity ratione personae. And then it is true, as Mr. Kress said, that later on in the judgment, arguing on the basis of Jus Cogens, the court reaches the conclusion that such immunity ratione personae does not apply in that case. But the real reason for the decision we find later in the judgment. Later in the judgment, the court, and I wish to quote for you, if I may, what the court says. It says, "We agree in this regard with the holding of both pretrial chamber 2 in the South Africa decision and the South African Supreme Court of Appeal decision in Minister of Justice versus Salk, both of which confirmed that 1, sitting heads of state ordinarily enjoy immunity under customary international law, and 2, that in principle, the ICC may not request the state party to arrest a sitting head of state," unquote. I pause here to emphasize that so far, that decision is quoting the very decisions that in fact upheld the absolute nature of immunity. Thank you.
Thank you very much. Counsel for Jordan, please.
Thank you, Mr. President. Mr. President, I just wanted to make 2 quick points that arose out of Judge Ibanez's question. Firstly, and I hesitate to get into this, but the Fujimori case, as I understand it, was a case where Peru itself requested extradition from Chile. So clearly Peru was not relying on any immunity that might have, its official might have been entitled to. So I think that is quite distinguishable. On the Pinochet case, I agree entirely with what Professor O'Keefe has said. I really wanted to take the floor to refer very briefly to paragraph 61 of the arrest warrant case, which Professor Kress and others have referred to quite often in these proceedings. I think it's very important. I agree with what Mr. Tladi has said about it, but it's very important to look at what the court actually says there, particularly about the International Criminal Court. In paragraph 61 it says, fourthly, an incumbent or former Minister for Foreign Affairs may be subject to criminal proceedings before certain international criminal courts where they have jurisdiction. And then it goes on to say, for example, examples include the International Criminal Court. It then says the latter statute expressly provides in Article 27, paragraph 2, that immunities or special procedural rules which may attach to the official capacity of a person, we know the rest of it, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. So it would seem to me that what the court said in paragraph 61 adds nothing to this case. It was merely stating the obvious, which is that under the statute of this court, there may be circumstances where people with immunity ratione personae, a foreign minister, for example, come before the court and cannot rely on immunity. That is the case if they are officials of states parties. So I don't read anything significant, unlike Professor Kress, into paragraph 61. I would respond, but I won't, to, we'll do it later, to what the prosecution have just repeated about their theory that there's some indeterminate area where the law is indeterminate between proceedings before an international criminal court and national proceedings. As we said yesterday, we think that is wholly wrong. We think there is nothing in the statute of the court that supports that rather extraordinary proposition, but we could elaborate that more detail at a subsequent stage in the proceedings. Thank you.
Thank you, Mr. President. For the record, I just would like to make a clarification because the quote of the representative of Jordan. Yeah, it's true. Peru didn't recognize the immunity of the former President Fujimori, but also it is true that former President Fujimori in the proceedings argued in his defense, the principle of immunity about him. And also it's true that Chile finally didn't recognize Fujimori's immunity. So there's two countries that didn't recognize this immunity alleged by, or argued by the former President Fujimori. Thank you.
Thank you very much. Now, Mr. Ward or Mr. Murphy, briefly on, while we've got some time, a reference has been made repeatedly to paragraph 60 and 61 of the arrest warrant case. I mean, what are we to make of Judge Akisone's dissent on that point? I note, of course, this morning when Mr. O'Keefe spoke, he counted numbers and said something about shellacking 4-2. But we also know there have been many instances in jurisprudence where a single dissenting opinion could later on turn things around in the development of the law. I'm not saying that's going to be the case here, but was he absolutely out of the realms of jurisprudential reasonableness? I mean, Judge Akesone in his dissent.
Thank you, Your Honor. Judge Al-Kassaoune was a member of and a judge of the International Court of Justice. He served there in his capacity as a judge, and as such, his views on the matter are related to himself. It does not reflect on Jordan's views on the matter. Now that you raised that, Your Honor, I would like to say that Judge Al-Kassaoune's view on the matter is related to the case being related to the Minister of Foreign Affairs. It's not a sitting head of state. And there's a big difference because the ultimate dismemberment of the state in the performance of its capacities when its sitting head of state is arrested by a foreign country.
When he spoke, he did not qualify it. He spoke in terms of the distinction. He just disapproved of the distinction being made between procedural and substantive immunities, saying that may well be translating into impunity. That's the point he made. I don't think he qualified it.
Thank you, Your Honor. Again, this is Judge Al-Kassaoune's personal views as a judge on the International Court of Justice, not Jordan. I would refer you to the decision by the court itself when it said immunity and responsibility are distinct. I can read that. This is the law. It's not. This is the law. It still is the law
The ICJ repeated that in Italy versus Germany, and there is no exception. Thank you, sir.
Thank you very much. And Judge Morrison next, please.
I'm really aiming this at Professor Mr. Robinson, because I know he likes obtuse questions. Gerald Fitzmaurice held that there was no conflict between domestic law and international law because they operated in different realms. Now, whatever the merits of that analysis, the basic principle is this, that no person or other legal entity can delegate a greater power than they themselves possess. Are there permissible exceptions to that premise in international law?
Off the top of my head, I can't think of any, but if any of my fellow professors have any examples, off the top of my head, I cannot think of a circumstance where states delegated what they don't have. But Rod, pardon me? No, even in the UN Charter, the member states pool together their sovereignty. They agree to comply with the UN Charter, but they are just binding themselves to it. But anyways, if I invite anyone else, off the top of my head, I don't think you can delegate what you don't have. I think it's just a fundamental. But I stand to be corrected if anyone has a thought.
I mean, I'm sure the academic colleagues here would be better placed, and I think Professor Kress has also talked about the jus penendi of the international community, but I think the only thing I would say that, of course, normally the rule of delegation applies, but one can think of, the very creation of the UN Charter establishes powers which individually those members cannot exercise. Now, that's done on the basis of consent, but all rules are created by consent. In the case of the ICC, we're not arguing that there is a necessity to go beyond the consent framework which is expressed in this context by the virtue of the creation of this Chapter 7 authority, which then triggers the obligation of the Rome Statute. So we think, and here we agree, I think, with Professor Robinson's earlier statement, that we don't need to go into wide-ranging areas of public international law to resolve this matter. We think we can confine it to the issues that are before us, which can be dealt with by examining the relevant treaty obligations that apply, and to that extent also to trigger analysis of the Arab League Convention if necessary. And certainly we would not want to fossilize the progressive development of the law if it may be going in a certain direction. But coming back to what Your Honour asked earlier, I think in this case there is something that has been delegated to the court by the Security Council, in fact, and the authority that is being exercised vis-a-vis Sudanese nationals is that which is delegated to the court. So I'm reversing, if you like, the scenario. I know that colleagues are not satisfied with my scenario of the UN Charter as the extraordinary constitutional framework, perhaps, but I think in any event we are returning back to delegation either way, because we believe that the framework within which we are operating here is one that is expressive of consent by the government of Sudan, whether directly or indirectly, and we say indirectly through the operation of the Security Council route. Maybe I've caused more confusion than clarity.
Thank you very much.
I'm very grateful for that, because now I can stop thinking about it.
Yes, Mr. Kress. Briefly, please.
I'm not offering an example, the example you have asked. I'm just reminding you that in my written observations, I've devoted a long paragraph to saying that your question does not exhaust the matter on this crucial issue. I would just, to remind you on that, I'm happy to elaborate at any instance, just for the record.
Well, this is confession and avoidance time. It was reading that paragraph that put the question into my head in the first place.
Thank you very much. Now we'll come back to Judge Tofmaski, and then next to Judge
thank you.
Rosa.
Thank you, Mr. President. I have a short question to Professor Newton. Did you also collect data about President al-Bashir's travels before the issuance of the first and second ICC arrest warrant? Would such data be helpful to determine whether there was any change in travel frequency as a result of these arrest warrants?
I think we have some limited data on that in the sense that we didn't go back. It's difficult to try to pick an arbitrary date, to say. I think we have some data from approximately the prior year, maybe the 18 months. I'd have to go back and actually check the data. And our analysis of that data showed no change at all. In fact, when you overlay, as we did in the annual charts, we were also interested in this interface between travel in an official capacity or some other private capacity and the actions or the engagements with the international chambers. So we overlaid that with prosecutors' reports. We overlaid that with the referral, the beginning involvement of the pretrial chamber. And what we saw was a consistency of travel of patterns.
But don't we need some sort of control picture so as to compare things? So if your data was collected over a certain period after the issuance of arrest warrant, the arrest warrant, do we need to also work backward before that, the same time frame, so as to try to make any reading out of the pattern, whether it's changed?
Well, as I said, based on the limited data that we have before the issuance of the first arrest warrant, the answer to your question, Your Honor, is that no, there was no change. And in fact, there was some periods in response to some things decreased travel in some circumstances. For example, in this narrow band, after the referral of Chad, and in that context, for the next year, there was no travel to states parties, the year 2012. But things are cyclical. So as an overall matter, we notice no change at all, subject to some certain circumstances. And this gets back actually in an interesting way, back to Judge Morrison's question, and in fact the President's observation with respect to Milosevic, et cetera. It's important to remember that in the ICTY and the ICTR context, those were very circumscribed, both temporal and geographic jurisdictions. So in response to your question, sir, I wouldn't have seen a reason for many other presidents to jump up and arbitrarily. And in that same context, until there was a valid arrest warrant and a valid Chapter 7 resolution, the rights of other states weren't even implicated. The rights of other travel weren't even implicated. It was only then that there began to be interchange between the organs of this court and the state officials of other states, both states parties and non-states parties. But the basic answer to Judge Hofmansky's question is that we've noticed no change at all in terms of the frequency, in terms of the rationales, et cetera, as a macro matter. There have been some periods for various reasons where you see some trends, but nothing on the whole, if that's responsive, sir.
Since you touched on the other matter about Milosevic, what about the picture of the Charles Taylor arrest, where he was a president of one country?
I think again,
right, but the events, the fact pattern in the case happened in a neighboring country. So we now have a cross-border scenario that's different from Rwanda and Yugoslavia in a sense, but still involved the unveiling of the indictment of a sitting head of state at the time, and in fact also an arrest warrant at the time. Doesn't it? And also, if you remember, as I seem to recall, his arrest warrant was served upon him when he was attending an ECOWAS meeting.
Yes, in a neighboring state.
The protest was that they were embarrassed about it, but
yes,
not for the fact of the indictment and the arrest warrant itself. Does it tell us anything?
In my mind, really not, Your Honor, which gets back to the observation a few minutes ago about the delegation of power. In that context, there was an indirect delegation through the Security Council. I think we recognize that. And other nation states said it's a very circumscribed jurisdiction. Only those who bear the greatest responsibility for this situation, for that, which indirectly and by extension included President Taylor. But again, he was not in office. You know, he had.
Do you remember if Colonel Gaddafi at the time protested because he was also implicated in the Sierra Leone events? And
not that I'm aware of.
Okay.
Not that I'm aware of, and there was a good reason for that, was because the joint criminal enterprise theory under which Gaddafi might have been implicated was pretty much discredited, both in academia and in practice, and it never really got off the ground.
It's not about the theory, whether Gaddafi read about joint criminal enterprise and understood it to protest. It's about the fact of indictment of a sitting head of state, a colleague of his.
Right. My reading, Your Honor, says that Mr. Gaddafi didn't feel threatened by that court because of the narrow circumscription of the power. And remember that this is an entirely different situation because this court is built on the delegation of power vis-a-vis ratification of the treaty. I've written about this and called it transferred territoriality, where you are transferring, and in fact under Article 27 states parties are waiving. This is a different issue.
Now, question from Judge Boza.
Let me start with a question related to that of Judge Hofmaski, and it is directed at Professor Newton. Is it correct that the data analyzed by you, Professor, are derived from publicly available information only, and that there may therefore be other trips of President al-Bashir that did not take place because invitations were not extended to him, or because it was made clear to him, for instance, through confidential diplomatic channels, that the inviting state would not heed his immunity if he decided to travel to a given state? If this is correct, is there not a risk that the data are tilted in one direction? I have a second question after this one.
I would say, Madam, that it's partially correct. You're absolutely right that there are, no doubt, may have been some private diplomatic correspondence. Much of that is captured in a number of ways. For example, analysis of the Security Council debates where those exchanges are recommended. But in fact, there's a number of press reports that talk about that private correspondence, and we've captured that. And the other thing is that in many of the correspondence as raised in the registry reports, there's mention of diplomatic communications. So I think you're right, absolutely. It's entirely possible that we've missed a few, but it's a very expansive search. And you're always trying to prove the negative. I had this conversation yesterday with somebody. You're always trying to prove the negative where the very possibility of arrest precludes trips. The data set contains a large number of cases that fit exactly that description, where there's a warning, for example, the trip to the United States to the UN General Assembly. Reported in the press, but the official exchanges for that were formal diplomatic correspondence. The trip to Malawi that was canceled in 2012 following the referral of Chad fits exactly the same category. That's in our data set because we've captured it from a number of other sources, some public, some private. The other thing that we've done, which again is maybe limited in our capacity to do it, is that where we knew there was a trip potentially planned to this location and that day, we've gone to the foreign ministry records and in some cases actually translated what the foreign ministry of the receiving country said, so Malawi or China or Saudi Arabia or Russia or some of those other countries. And again, that doesn't reflect the private correspondence, but it reflects the fact that there was correspondence and that the net result of that correspondence was a canceled trip. So I can't speak to some cases that might be out there that we don't know, but I will tell you, Madam, that we've done our very best to capture the ones that we do know about, and more importantly, to drill down into the reasons why. So it's a hypothetical, and the short answer to your question is it's partially true.
Thank you, Professor. The next question is actually addressed to the AU delegation because it arises from the submissions of the professor. do you consider that the UN Chapter 7 resolution needs interpretation in accordance, in light of the provisions of Article 13B and 16 of the statute, the Rome Statute?
Well, thank you very much, Your Honor. I think that's a very important question, and of course, when we get down into the Group B questions, we'll drill down much more into that question. So what I will say for now is the following. Indeed, a UN Security Council resolution has to be interpreted. We have heard two basic grounds which suggest that on the basis of UN Security Council resolutions, there's a duty to arrest. So the first ground is that the UN Security Council resolution itself waives immunity. Right? For that, you have to interpret the UN Security Council resolution itself to see if in fact it does that. You'd have to look at operative paragraph 2, and you'd have to apply the rules of interpretation. And as we will show you when we tackle the Group B questions, when you apply each and every single means of interpretation to that UN Security Council resolution, you come to a single conclusion, and that conclusion is that immunity must be respected. The other legal theory that has been advanced, of course, is a combination of the UN Security Council resolution itself and Article 13B, which would suggest that Sudan is placed in a position analogous to that of a state party. Again, as with the first theory, that depends on fictions and conjecture. There is nothing, if you apply the rules of interpretation to Article 13B, there is nothing that leads to that conclusion. Article 13B, if you apply the rules of interpretation, good faith, ordinary meaning, context, object, and purpose, all direct to one thing. Article 13B grants the ICC jurisdiction over the situation. It does nothing more than that. Every other single rule in the Rome Statute continues to apply. So Article 27 applies, of course, but also Article 98 applies. So indeed, you have to apply the rules of interpretation, but our submission will be that the application of those rules of interpretation lead you to a single conclusion, and that was Pretrial Chamber 2 erred in its findings. I thank you.
What about Article 16?
So Article 16 concerns the power to defer. And yes, that also is subject to...
May I complete my question?
Yes, please.
Doesn't that implicitly, that isn't the presence of this article in the statute an implicit or even explicit indication that when a referral is made, what is expected to follow are investigations and prosecutions?
Well, indeed, a proper interpretation of all the provisions of the statute, and that would include Article 13B, but it would also include Article 16, is that when a referral is made, there is a duty to investigate and then, if necessary, to prosecute. Absolutely, there is no disagreement about that. The question, though, is what does that mean for immunity? And our response is that it means nothing for immunity. Every other provision of the statute continues to apply. So Article 19 continues to apply. You're absolutely right, Joanna. It creates an obligation, or it creates the possibility for the office of the prosecutor to investigate and, if needs be, bring charges. But that says nothing, absolutely nothing about the rules relating to immunity.
Mr. Tladi, I'm going to... there's this elephant in the room in relation to that provision, Article 16, and this case in particular. And it is this. I think it's a matter of, we can call it judicial notice. We can agree that the African Union made a request for deferral pursuant, that's after the indictment of President Bashir. The arrest warrant was issued, after the arrest warrant was issued. He made a specific request for deferral under Article 16. The Security Council did not defer. Does that tell us anything?
Indeed, it tells us a lot, but it doesn't tell us anything about immunity.
And that's precisely about immunity. Does it tell us anything about immunity?
It tells us absolutely nothing about immunity. So let me just say a couple of things. In fact, the first request for a deferral came before the arrest warrant. It came in 2008, and it was the AU Peace and Security Council rather than the Assembly that requested a deferral. So that was the first one. But understand what the basis for the referral was. The basis for the referral was not that it is President al-Bashir that's been indicted. That was not the basis of the request for deferral. The basis of the request for deferral was that there were ongoing peace negotiations, and that indeed a deferral under Article 16 would be appropriate because it would allow those ongoing processes for peace to continue. It had nothing to do with immunity. Thank you. You want to add something? Add something if you permit.
Yes, please, proceed.
Thank you, Your Honors. It's a great privilege to appear before you. And if I may, I'm trying to exercise a lot of restraint out of courtesy. Of course, Mr. Tladi has been dealing with the Group A questions. But if I could offer a couple of observations, with your permission, with respect to Judge Bosa's question. The first observation relates to Article 13b of the Rome Statute. She suggested a link to Article 16, which deals with deferrals. That is indeed correct. But I think if we step back, it raises another interesting question that Mr. Tladi has not raised, which is, what is the whole point of having the Security Council involved in matters of international criminal justice as applied by the International Criminal Court? If we look at the history, the drafting history of the Rome Statute, we would find at least two opposite views. One view was we could have the Security Council be involved in matters relating to international criminal justice because in any event, the Council had developed, or at least began to develop, a kind of practice where it would create tribunals. And we had two examples at that point, the Yugoslavia scenario with the ICTY and, of course, ICTR with respect to Rwanda. Now, there was the opposite view where countries were uncomfortable with the idea of Security Council involvement. And the reason primarily was that you are going to politicize the court. But in the end, the view prevailed that we should have a role for the Security Council because, in fact, it exercises an important responsibility for the maintenance of international peace and security under the Charter. That could then mean, if we allow the Security Council to send referrals to the court, where it deems that the possible investigation and prosecutions of international crimes could contribute, and underscore could, because we do not know as an empirical matter, then that's fine. But that does not bind the court to proceed. In fact, if you look very carefully at the text, the investigation could happen after a referral, and the prosecutor may choose not to proceed. That was something I wanted to underscore. With respect to Article 16, then, what does it mean? It means if there is an ongoing investigation or prosecution, and the Council determines that that could be problematic for its own role, its own primary responsibility to maintain international peace and security, it could say to the court, well, hang on, stop. And there was a qualifier. You can stop for a year, and if the Council wants to change that, it has to come back each time to have a conversation with the other members of the Council so it could make that determination. So the fact that in the context of the fact pattern we are looking at here, where the AU requested at least on a couple of occasions a deferral, goes more centrally to the question of peace versus justice and the sequencing of peace in the Sudan, keeping in mind that there had been engagements by the AU with respect to settling the long conflict in the Sudan. Not so much a question of immunity. Immunity was not in the minds of the AU when they made that request. So I hope that's helpful to Your Honors. Of course, we'll be coming back to the issue of the Security Council and its role much later on. And Your Honors, if I may just very briefly to say, I was very provoked by your question about the SCSL in relation to the Taylor arrest, but then, of course, I missed the opportunity to jump in because I didn't want to overstep my bounds with respect to Mr. Tladi. But it is an interesting scenario that you pose. But there's an element of the relationship of that question in terms of Ghana and other African states and their own reaction, because they were, of course, not happy with the issuance of an arrest warrant in the middle of a peace negotiation. Thank you, Your Honors.
Thank you. They put one of my own, as if I haven't done that already. I'm going to read in some material, if you don't mind. I want to set the stage, and I do so by going to the joint separate opinions of separate opinion of Judges Higgins, Goemans, and Bergenthal in arrest warrants case. Paragraph 5 of that says this, if I may, towards the middle. And by the way, Mr. Murphy, I would like you to respond to this if you don't mind, because you didn't get enough chance to speak in the morning or so far. And the quote is this. I'll begin with it, and I'll go to Barcelona traction case, beginning with the joint opinion. So it's quote, one of the challenges of present-day international law is to provide for stability of international relations and effective international intercourse, while at the same time guaranteeing respect for human rights. The difficult task that international law today faces is to provide that stability in international relations by a means other than the impunity of those responsible for major human rights violations. This challenge is reflected in the present dispute, and the court should surely be engaged in this task, even as it fulfills its function of resolving a dispute that has arisen before it. But through choosing to look at half the story, immunity, it is not in a position to do so, unquote. I think we can agree that maybe that's where we are. But now let's look at how to resolve it, whether this is one way to look at it. And so we go to Barcelona traction case, paragraph 33 and 34. But I'm going to read the whole thing onto the record, both of them. 33 says, when a state admits into its territory foreign investments or foreign nationals, whether natural or juristic persons, it is bound to extend to them the protection of the law and assumes obligations concerning the treatment to be afforded them. These obligations, however, are neither absolute nor unqualified. In particular, an essential distinction should be drawn between the obligations of a state towards the international community as a whole and those arising vis-à-vis another state in the field of diplomatic protection. But by their very nature, the former are the concern of all states in view of the importance of the rights involved. All states can be held to have a legal interest in their protection. They are obligations erga omnes. And it continues, paragraph 34. Such obligations derive from, for example, in contemporary international law, from the outlawing of acts of aggression and of genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Some of the corresponding rights of protection have entered into the body of general international law, quotes the reservation to the Convention of Genocide case. Others are conferred by international instruments of a universal or quasi-universal character, unquote. The question then becomes this. These two quotes, one from Higgins and Coimans and Bergenthal on the one hand, and the opinion, paragraph 33 and 34 in Barcelona, do they help us in resolving this matter, especially in light of Judge Ibanez's first question, is immunity absolute?
Well, thank you, Mr. President. Starting with the separate opinion of Judges Higgins, Bergenthal, and Koymans in the arrest warrant case. I think it is worth emphasizing it's a separate opinion. It's not a dissent. And therefore, the judges were fully in accordance with the majority's view with respect to the immunity issue. Therefore, those three judges were fully in agreement with the proposition that a sitting foreign minister, and they included with that a sitting head of state, is absolutely immune from the foreign criminal jurisdiction of Belgium. I would interpret that particular paragraph of their separate opinion,
which says that looking at immunity is looking at half the story.
Exactly, which says that we're looking at half the story. I would interpret that as the three judges saying we would have liked the court to address the fact that Belgium has jurisdiction in the case, which is what they then go on to discuss in the separate opinion. So they would come to a conclusion that there's jurisdiction over the foreign minister, but that does not mean a lack of immunity. And so for purposes of this proceeding, I think a comparable scenario would be an acceptance that this court has jurisdiction in this case, but that there is nevertheless an immunity present that needs to be taken account of in the context of the way the court statute operates.
And that takes us to Barcelona traction.
So in the context of the Barcelona traction case, our view is that the case stands for the proposition that when a state, and I emphasize a state because it's not talking there about an individual in a criminal context, I would emphasize that a state that commits certain egregious acts, to include genocide, crimes against humanity, it is possible in that situation for other states to regard themselves as enabled to bring a claim. Because even if their nationals have not been harmed, nevertheless, the nature of the offense is one that is an obligation owed erga omnes that would allow other states to bring a claim. Consequently, in this context, a country such as Jordan, in theory, could bring a claim against a country such as Sudan, possibly for alleged genocide, crimes against humanity, and so on. But Jordan is not obligated to do that under Barcelona traction. And since the decision was issued in the 1950s, no state has viewed those paragraphs as obligating states to bring claims against other states.
Is there some, at a level of abstraction, where paragraph 33 is telling us that, look, when someone comes into your territory, there are rules of international law that govern what you do with them while they are in your territory, be it diplomatic protection, and so on. But that is not exclusive. There are other considerations that must also be taken into account in order to adjust, so to speak, the right result in the particular circumstances. And this genocide convention, I know Mr. O'Keefe says there is no exception, including for genocide. I'm not sure that that's what Barcelona traction tells us. That's the point of the matter, though. Is there any principle to be distilled from paragraphs 33 and 34?
I think the only principle would be that on that interstate level, it does enable a country perhaps to bring a claim. I don't think it speaks to the possibility that when an official travels to your country, you are enabled to arrest that person notwithstanding the existence of these immunities. I just don't think the one carries over to the other. And just to emphasize again, even in the arrest warrant case, the court was quite clear the existence of jurisdiction does not imply the absence of immunity. That's the heart of it. And I think that that does have to be kept in mind, even as we read separate or even possibly dissenting opinions.
But then again, maybe this is your chance to speak to it. I've asked that question to a number of speakers in the past who've spoken. Doesn't that assume a lot of unstated variables, that kind of distinction? One of them being, for instance, that evidence does not deteriorate with time. Victims of the conduct live forever, so do witnesses, so that a head of state who is head of state for life, it is possible for us to wait and not worry that sometime in the future there will be a prosecution to benefit the victims and the case will be intact. Isn't that some of the things we need to deal with for purposes of that distinction that was made in paragraph 60 and 61?
Well, I think the court, in all likelihood, would have acknowledged that these factors do exist.
They do in paragraph 61. Well, not quite.
Well, they don't, I think, go into it in the way that you have, but I think their answer was there is a possibility of waiver. There is a possibility that an official falls from power and then can be prosecuted. There is the possibility that they themselves walk in your door here and you have jurisdiction and they can't claim immunity from you under Article 27. These are unsatisfactory answers in certain contexts where, as you say, head of state for life, you know, how do we get at them? But I do think that the court nevertheless says in the arrest warrant case, immunity ratione personae from foreign criminal jurisdiction is absolute, for very much the reasons that I believe it was Professor O'Keefe was talking about, is absolute because of a belief that we do have a need for interstate conversation, the ability to interact among each other. And without that, denying that possibility for foreign ministers and heads of states and government is a very serious intrusion into their ability to function. And that's an important value that I think the court in the arrest warrant case was recognizing, and that is fully consistent as well with its other decisions in the context of, for example, Germany versus Italy. So I think that's where we stand, and as unsatisfactory as it may be, that is the law.
When I mentioned Judge Arcasone, it wasn't because he was Jordanian. I want to make that very clear. Just that he is a jurist of serious pedigree, and he disagreed that that distinction is practical, the result in practical, it achieves practical result. And so, in a sense, to the joint judges who wrote the joint opinion, Judge Higgins, Coimans, and Bergenthal, that it may be a little too, like a will o' the wisp to say, well, let's wait until they get out of office and we'll then do something. Are we to ignore those dissenting opinions on that point?
Well, I don't know as one would ignore it, but I would first focus on the fact that it's a single judge and it's a dissent, and that this matter was fully litigated before the court, and that the court overwhelmingly came down in the place that it came down.
A single dissent. What happened in Dred Scott case? Remember Dred Scott, Sanford and Dred Scott in the U.S., where the majority of the U.S. Supreme Court once held that slaves could not be citizens of the United States. There was one dissenting judge who disagreed with that, but the majority ruled in a certain way, saying that was the case. But then later on, that dissenting judge, his views seem to have turned the table down the line.
And we're all glad that that did change, Your Honor, and I think we can probably go to many different jurisdictions and find circumstances where bad decisions are issued and at some later time we change. I would submit, though, that the arrest warrant case, a relatively recent decision, is fully consistent with the other decisions of the court. One could talk about the Djibouti versus France case, fully consistent with this idea of immunity ratione personae being absolute from foreign criminal jurisdiction, and fully consistent with decisions taken in national courts as well. So the story here is not of an aberrant international court in the arrest warrant going off in some crazy direction and the lone judge standing up and saying something that others look at and say, that's right. I think that's not the narrative that one would take from that case.
Your Honours.
Thank you very much.
Perhaps if I might intervene briefly on the same question. Thank you, Your Honours.
Please.
I do so very cautiously to begin with, but bearing in mind Your Honours' reference to Barcelona traction yesterday, we also went away last night and had another look at it. The first comment we would make is that by and large, I think we agree very much with Mr. Murphy's cautious explanation of the scope of what it means when we talk about an obligation erga omnes. And for example, Article 48 of the ILC Articles on State Responsibility suggests that it's, again, a right of standing for states to raise certain violations. But if I may be so bold, I think the question which underlies Your Honour's question is the notion which we've all circled around at different points in the last day and a half, which is whether immunity always means impunity. And it's that question which perhaps we start to see in this context. For example, what about the possibility that states may be able to take certain actions within the realms of their existing obligations under international law, so not departing from any positive role, but within those realms, which may assist in combating impunity when there has been a violation of an obligation erga omnes. One example of that might be, for example, my learned friend from the Arab League yesterday referred to, I think, Article 14 of the Pact of the Arab League, which says that member states shall waive immunity when essentially the interests of justice require and when it will not defeat the purpose for which the immunity was granted. Perhaps we say under those circumstances the breach of an obligation erga omnes might be, if you like, the archetypal situation when states may be expected to take that right that they have, and indeed that duty under international law and under that treaty. We would also, on the other hand, be very cautious in noting that the international community is clearly grappling with what it means when it says immunity must not mean impunity. So, for example, in the 6th report of the ILC Special Rapporteur Ms. Hernandez, and that's cited in our written submissions, but it's paragraph 17 of that report, when talking about her conclusions, as we understand it, in her proposal of this draft Article 17, draft Article 7, I beg your pardon, and she describes how the reaction to this is very, very varied. But she says that the one thing that states do more or less agree on is the notion that immunity must not mean impunity, even though they disagree as to exactly how to achieve that. And again, this same notion that there might one day be a tension, we see it sometimes in some human rights cases, and Your Honours have described some scenarios whereby there may be, you can think of hypotheticals where immunity becomes very uncomfortable. For all those reasons, Your Honours, we would say that we would take a lot of caution with the positive rules of international law that we're talking about, Jus Cogens, obligations erga omnes, and so on and so forth. But here, at this court, where the question before us is how we interpret the obligations that are in the statute and are in the UN Security Council resolution, then maybe there it's these same considerations which might inform our interpretation of the rules that we have, and there maybe they will find some value to our discussion. Thank you, Your Honours.
Yes. Mr. O'Keefe.
Mr. President, if I may make one very legal technical point and one jurisprudential point about what has been spoken about. The legal technical point comes from the last intervention by counsel for the prosecutor, which does not really go to the question of standing. What the prosecutor seemed to be suggesting is that a state might take third-party countermeasures against a state which breaches an obligation erga omnes. In other words, what the prosecutor in some ways seemed to be suggesting, although it was admirably cautious in not quite coming to this, is saying states in the exercise of their right might do these things. The exercise of their right has been codified in Article 48 of the Articles on Responsibility of States. It is limited to bringing a claim for cessation and non-repetition or for reparations on behalf of the injured state or beneficiaries. Rather, what the prosecutor, although again strictly saying keeping within the law, but seemed to be suggesting is in fact, well, it might be within the realm of their rights not to accord immunity in response to a violation of an obligation erga omnes. Mr. President, in diplomatic and consular staff in Tehran, the famous case in the International Court of Justice involving the 444 days spent in violation, in flagrant violation of the rules of diplomatic immunity, where an argument was raised that in response to that, perhaps the United States might itself be able to take measures which would otherwise be unlawful. The court, using the unfortunate language of a self-contained regime, but we knew what it meant, said that is not how it works in the system of diplomatic immunity. In diplomatic immunity, you stick to the rules that are provided for, which include declaring someone persona non grata, etc. So what the court would seem to be saying in our present case is, well, Sudan may have violated its obligations erga omnes, but that does not justify lifting the immunity. Now, on the jurisprudential point, Your Honour, Mr. President, you touch on something very fundamental, and that is whether the rule of law is to be relaxed to account for contingent fact. We have a rule which is absolute. It's a rule generally applicable across the board. Now, I would add that the states in framing this rule are perfectly well aware that there are situations in which we have presidents for life, are perfectly well aware in which we have situations in which a head of state has done egregious things, but they have nonetheless framed that rule. Now, are we to relax the rule of law because in certain contingent situations, the outcome may be unpalatable? We are human. We see that people have suffered. The terrible temptation is to relax the rule of law, to change the systems, the rules on which we have agreed, to take account of what is the deeply human reaction to this situation. But the courage of the court and the courage of the judge is to stick to the rule of law. The courage of the court and the courage of the judge is to accept that there are hard cases which look ugly and that they may take some flack for it. But these are the rules agreed on, and those rules do contemplate, perhaps if you put it in informal terms, what you would refer to as, let's say, constructive impunity. But it is not formal impunity, and those are the rules that are agreed.
But it may well be more than the unpalatability of an outcome. We may look at it from, let's say, from the backyard, so to speak, in the sense of asking the question, what happens really in circumstances where the host state ignores the claim of immunity of a visiting head of state who is under indictment for genocide and decide, we are going to arrest you, sir, and send you to the ICC. As a practical question being this, what will happen to the guest state? Here, that takes us, doesn't it, to the concept of responsibility of states for internationally wrongful act, for which the breach of which results in reparation. You go to the ICJ to make a claim. Would they succeed? Would the guest state succeed in that claim for reparation because they had indicted somebody who was under an arrest warrant for the crime of genocide? In answering that question, you may explain to us, since you mentioned that those draft articles, what draft articles 40 and 41 is telling us in that regard.
Right. Well, Mr. President, you touch upon Articles 40 and 41, and this was precisely a point raised in the case, in the civil context, between Germany and Italy. What Italy had argued is, in the civil context, essentially what you're arguing here, which is that could we not say that the removal of Germany's immunity from civil proceedings and from civil execution was a measure taken pursuant to our obligations recognized in Articles 40 and 41 of the Articles on Responsibility of States?
The difference is that in that case, Italy was exercising its own jurisdiction. But in the fact scenario I gave you, I said, so we're going to arrest you and send you to the ICC for trial.
Yes. Yeah, well, Mr. President, you touch on another fundamental question here. Let's just say it's Jordan, and let's just say it's Mr. al-Bashir. Jordan's police arrest Mr. al-Bashir. Let's say under Jordanian law, a judicial proceeding is required for surrender. A Jordanian court will hear that proceeding. Now, if the Jordanian police and the Jordanian courts do not represent an exercise of criminal jurisdiction by Jordan of its own jurisdiction, then whose jurisdiction is it? It's not the international courts, because they're Jordanian police. Okay, this is what really this boils down to, Mr. President. When it's the Jordanian police and when it's the Jordanian courts, that is an exercise by Jordan of its criminal jurisdiction. Now, that isn't necessarily the end of the story, because, of course, there may then be a customary exception to immunity from Jordan's criminal jurisdiction in respect of surrender to the court. But that has to be proved positively by the prosecutor, and so far what we've had from the prosecutor is that it's unsettled. Well, unsettled does not displace a settled rule of customary international law, which says that the exercise by Jordan, by its police, by its courts of jurisdiction, violates the immunity.
Well, thank you very much, Your Honor. Just a couple of points. First of all, I share entirely the views that have just been expressed by Mr. O'Keefe and earlier by Mr. Murphy. I just want to make a couple of additional points. And in fact, the first point starts off precisely where he left off with draft articles 40 and 41. What we have to remember, though, and I was just trying to pull them up and I haven't been able to pull them up, but what we have to remember, though, is that both of those draft articles specifically say that the measures that are to be taken are measures within the law, right? So they have to be respectful of international law. And of course, international law would then include also the obligations relating to immunity. Again, on the question of the Barcelona traction case, there is an issue that we ought not to forget in sort of trying to figure out what the paragraphs that you have read into the record mean. We ought not to forget that many, many years after that decision has been given, there was the arrest warrant case, which did not read into those paragraphs the complete removal of immunity, ratio in personae. There was the jurisdictional immunities case in Germany versus Italy, which did not read into those paragraphs this idea that those paragraphs remove immunity, right? It seems clear, and I think there's a general agreement even amongst the participants in these proceedings, with very few exceptions, that there is no exception to this rule relating to customary international law, and it has been said over and over again. We have been presented with some practice, right? So we've been presented with some practice, but if you look at that practice, that practice all pertains to the same issue. The practice that the Office of the Prosecutor has presented to us all relates to the matter of Mr. al-Bashir. So it cannot be practice that constrains the court. The final point that I'd like to leave you with, which I think is a point that was made both by Mr. Murphy and Mr. O'Keefe, is that it is important, as uncomfortable as some situations are, that this court, if it is to be seen as a court of law, if it is to be seen as a court that is bound by the rule of law, allows itself to be constrained by its rules, even if the outcomes are uncomfortable.
You said you did not have Article
41.
41.
I'm just
the
pulling it
reference
up.
to 41. Perhaps you can speak to this quickly. Actually, the interest is in 41.2, draft Article 41, paragraph 2, if I may quote.
Yeah.
No state shall recognize as lawful a situation created by a serious breach within the meaning of Article 40,
Correct.
nor render aid or assistance in maintaining that situation, unquote. Article 40 deals with jus cogens. Now, the question then becomes, is it, of course we know, typical situation where, there's an occupation, a new state, some illegal occupation, and the occupying state creates aside some jurisdiction, international community says, no, that's unlawful, no recognition. But that cannot be the only situation that 41.2 speaks to. Question is, could 41.2 include a scenario where a breach of a peremptory norm, say genocide has been committed, and there's an obligation to repress and punish? So we have effectively an unlawful situation under international law. Can that be recognized as lawful when a person who's under indictment shows up in another state and saying, hang on, I have immunity?
I'm very embarrassed to say this, Your Honor, but in fact, in my last report to the International Law Commission on jus cogens, I consider precisely the meaning of that particular provision. Obviously, we haven't included it as our materials, but thankfully, the Office of the Prosecutor has included the third report on jus cogens. So I'll just say a couple of things about that particular report, or this particular provision. The report makes it clear, after an analysis not only of the commentary to that provision, but also of the case law to which that provision is based, that particular provision, or this particular provision, in this instance would mean there is a duty on states not to recognize the violation of jus cogens, and the violation of jus cogens in this instance is the commission of the crime of genocide. That's what's not to be recognized, right? In terms of providing
they can recognize immunity from that?
But this takes us back to the ICJ judgment in Germany versus Italy to say these are two different concepts that operate on two different things. Again, we seem to be conflating. They are two different things. And so the recognition of genocide or the non-recognition of genocide does not mean the non-recognition of immunity, because they are two different things and there's no conflict between them. With respect to the second part of the provision that you read out, providing aid or assistance would mean a state coming in and assisting in the commission of those crimes. There is no relationship with this provision, or rather between this provision and the rules on immunity.
Can we look at it in terms of it not just assisting the commission of genocide? It says here, no, render aid or assistance in maintaining that situation. That situation meaning a situation of non-punishment of the crime of genocide, which the Genocide Convention obligates states to assist in, isn't it?
No, I would disagree. That situation is not the maintenance of the non-punishment. That situation is the maintenance of the situation of the commission of the crime. It's a different thing. It's not about immunity. Thank you.
Yes, we have Professor Lutanzi, please.
Merci, Monsieur le Président. J'avais cherché avant de prendre la parole, mais on ne m'a pas vu. Donc, vous me permettez, s'il vous plaît, de revenir un moment sur les questions posées par la juge Bossa. Ah, yes. Yes. Alors, il y avait là deux questions que je trouve très pertinentes. L'une, c'est celle de l'interprétation possible de la résolution 1593 sur la base de l'article 13b, et l'autre sur la base du pouvoir donné au Conseil de sécurité de stopper des procédures devant la Cour pénale internationale. En ce qui concerne la première question, naturellement, le Conseil de sécurité a rendu la décision 1593 sur la base des pouvoirs au sens du chapitre 7, mais aussi sur la base d'une prévision spécifique contenue dans l'article 13b, d'utiliser ce mécanisme, le chapitre 7, donc le Conseil de sécurité, selon ses pouvoirs du Conseil de sécurité. Donc, cela signifie que la résolution doit être absolument interprétée aussi sur la base de l'article 13b. Et donc aussi du chapeau qui mentionne expressément que la Cour exercera sa juridiction selon les règles du statut. En ce qui concerne après le pouvoir du Conseil de sécurité sur la base de l'article 16 et toujours selon ses pouvoirs au sens du chapitre 7, je dirais que elle aussi, cet article 16 et la possibilité du Conseil de sécurité de l'utiliser peut nous aider à comprendre la résolution 1593. Pourquoi? Parce qu'ici, on a entendu que pourquoi, et beaucoup l'ont écrit, certains académiciens aussi, pourquoi le Conseil de sécurité n'aurait pas explicitement fait exception à l'immunité des représentants du gouvernement soudanais. Mais si le Conseil de sécurité, je chercherai à le démontrer demain pourquoi il ne l'a pas fait. Mais en tout cas, l'argument est aussi valide si vraiment le Conseil de sécurité avait considéré que M. al-Bashir, le président al-Bashir, jouit de l'immunité, il aurait bien pu utiliser l'article 16 du statut et donc interrompre la procédure pour un certain temps qui peut, comme on le sait bien, devenir même infini. Renouveler, dit l'article 16, il peut bien renouveler cette décision d'interrompre. Il ne l'a pas fait, même s'il y a eu beaucoup de dénonciations dans les rapports périodiques du procureur de la non-coopération des États dans l'exécution de la demande d'arrêt et de remise. Donc, je pense que c'est les deux questions posées par Madame... cette question posée par la juge Bossa à propos de l'utilisation de l'article 13 et de la compétence du Conseil sur la base de l'article 16 sont très pertinentes. Mais si vous me permettez, je voudrais aussi revenir un peu sur tout ce débat concernant la question du caractère absolu ou non de l'immunité. L'immunité en particulier personnelle du chef d'État. Alors, il faut quand même utiliser les mots dans leur sens. On ne peut pas confondre le caractère général d'une règle coutumière avec son caractère absolu, et même pas avec la notion du jus cogens. Vous savez bien que même le droit à la vie est objet dans le droit international, est l'objet dans le droit international d'une norme de jus cogens. Mais nonobstant cela, comme aussi la Cour américaine des droits de l'homme l'a dit, ce n'est pas un droit absolu, parce qu'il y a la peine de mort et le droit international n'a pas encore pu résoudre ce problème en interdisant la peine de mort. Il y a la possibilité de tuer en guerre l'ennemi, donc le droit à la vie est jus cogens, mais n'est pas absolu. Tant moins est absolu, excusez-moi, le droit de l'État, d'un État à l'immunité personnelle sur le plan rationnel, personne de son chef d'État. Et alors, je dis qu'il ne faut pas confondre les immunités, les droits aux immunités dont jouit un État en tant que tel, qui ont trait à sa souveraineté et au principe par imparem non habet jurisdictionem. Il ne faut pas confondre ce droit avec le droit qu'un État a à ce qu'on lui reconnaisse l'immunité du chef d'État devant les juridictions étrangères. Cela, c'est une chose qui a trait à un intérêt complètement différent, qui n'a pas la haute protection qui a la souveraineté d'un État. C'est simplement de dire que les représentants des États qui ont automatiquement le ius representationis omnibode. C'est le chef d'État, peut-être aussi le ministre des Affaires étrangères, comme la Cour internationale de justice l'a dit, peut-être les chefs de gouvernement aussi, doivent expliquer leurs fonctions sans entrave partout. Mais cela ne signifie pas que ce droit d'un État ne subit pas de restrictions. Le fait même que l'État puisse renoncer, que le statut de la Cour pénale internationale puisse prévoir l'exception, et personne n'a dit « ah non, c'est invalide cette disposition du statut », qu'il y a la possibilité, même si, comme les crimes de guerre, ce sont des faits qui sont sûrement commis, des violations très graves qui sont commises dans l'exercice de leurs fonctions officielles, de faire la guerre et de ne pas respecter le droit international humanitaire en guerre. Mais quand même, l'immunité donc des agents d'État, les immunités des agents d'État, parce que c'est différent, ratione per persone ou selon la fonction, ratione materie, sont dérogeables. On peut déroger et donc n'ont pas de caractère jus cogens et n'ont pas un caractère absolu. J'avais, à propos d'une question dont a parlé le représentant, un des représentants du procureur. Il faudrait quand même se rappeler aussi en lisant les travaux préparatoires. Ce sont des milliers quand même de travaux préparatoires du statut de la Cour pénale internationale, mais ils révèlent très clairement ce qui a été l'esprit pour l'institution de cette Cour. Et que la raison fondamentale sur la base de laquelle à la communauté internationale, depuis Versailles, a commencé à naître cette exigence d'un mécanisme pénal international, c'est sur la base du principe, pour ainsi dire, substantiel, pas formel, naturellement, de complémentarité, comme après il a été consacré dans le statut. C'est-à-dire, les États négligent la répression des crimes de droit international. Donc, et surtout négligent cela quand il y a l'implication des hauts représentants des États. Donc, il faut, pour contraster cette situation, il faut créer un mécanisme international. Et alors, donc, cela signifie que la Cour pénale internationale a prévu l'article 27, excusez-moi, que les États ont prévu l'article 27 dans le statut de la Cour pénale internationale, surtout pour faire face à cette négligence des États, des juridictions nationales. Et donc, on prétend d'appliquer les immunités qui déjà, devant les juridictions internationales, sont en train de subir une érosion. C'est quand même assez drôle. Merci.
Thank you very much. I will invite the Council for the League of Arab States to address the court, and also put on the record that he has now joined us. He was not here in the morning session. Please proceed.
Thank you, Your Honor, and apologies for coming a little bit late in the morning for some consultation purposes. Let me start by by referring to the question that you posed to the League of Arab States yesterday with regard to Article 98 of the Rome Statute, whether the League is advocating for the application more of paragraph 1 of Article 98 or of paragraph 2. And I have checked with our legal team back home, and I am instructed to say that we attach great importance for the application of both paragraphs of Article 98 of the Rome Statute. I would like to make a further comment on the application of Article 14 of the 1953 Convention that based on the comments that were made by the distinguished representative of the prosecutor. And in fact, with regard to the waivers, the paragraph 14 is very clear. It states that, and I'm quoting here, consequently, member states, and here the reference is for the sending states, must waive the immunity of their representatives, and this is the emphasis that, this is the sending states that are instructed in all cases where it appears that the immunity would impede the course of justice. And that runs, of course, in parallel with the provisions that are stipulated in paragraph 98 of the Rome Statute. And if it can be waived, and this is the tricky part, without prejudice to the purpose for which the immunity is accorded. So that is a condition for the waiver of immunity. But who is going to decide that there is no prejudice to the purpose for which the immunity is accorded?
But I thought the purpose would be for the efficient functioning of the Arab League.
Exactly. Okay. But it is the Arab League that is going to decide. It is not Sudan, it is not Jordan, and it is not the court. So that distinction has to be very clear in the application, that the Arab League is the one that's going to decide according to the institutional procedures as a depository of the 1953 Convention. Thank you.
Thank you very much. Next is Mr. Kreis. Did you ask to speak? I have you on the list.
Yes.
All right. After you, then we'll go to Jordan.
I can defer to Jordan happily,
Fair enough.
if you wish.
Yes. Thank you, Mr. President. Just a small reminder that in the arrest warrant case, the charges against the foreign minister did relate to crimes against humanity and serious war crimes. So whether we're talking about jus cogens or whether we're talking about erga omnes obligations, those kinds of issues were certainly before the court when they reached the decision that we reached, and I think it's important.
But I think it's important also to clarify that the only judge who talked about jus cogens was Judge Akesone, and no other.
Well,
in the arrest warrant case.
Yeah, the international court case best to look at on the jus cogens issue would be the Germany v. Italy case, where it was squarely in front of the court, and the court was quite clear that an allegation of a jus cogens violation did not have the effect of overriding immunity. That's where they did clearly set up the idea that there's a procedural side to things, there's a substantive law side to things, and these are two different things.
So then, if there's any serious doubt about that distinction, does the thesis collapse then?
Well, I think it comes down to, at least in that context of jus cogens, how you conceive of what is jus cogens. Jus cogens is saying you cannot commit certain types of acts, and you can't do that by basis of a treaty. You can't do that by the basis of something else. If you accord immunity to someone, you're not committing that act. When Jordan recognizes the immunity of President al-Bashir, it's not committing an act of genocide. It's not committing crimes against humanity. It is not transgressing a peremptory norm of international law. I think that's the heart of what the court was discussing in the Germany v. Italy case.
But is it possible that the court's distinction for purposes of saying there was no conflict of jus cogens with immunity was by saying they speak to different considerations, the two ideas in that case, and they address immunity as speaking to something else, whereas jus cogens speaks a different interest. I think that seems to be an understanding of how they arrived at that distinction. The question then becomes this: are we in a scenario, for instance, where there's a law in a national jurisdiction that says when a motorist and a cyclist conflict on the highway, on the roadway, in order to preserve life, the motorist should yield to the cyclist. But then we have a scenario where the two, at some point, arrive at a roundabout and there's a collision. And the judge says, well, there is no conflict that should have resulted in the motorist yielding in this scenario because a motor vehicle serves as a different mode of transportation, whereas a bicycle is of a different character and serves a different mode of transport. Do we have that problem with that kind of distinction that was made in the arrest warrant case?
No, I don't think so. If I understand the hypothetical correctly, in both instances, the question is, can you engage in an act that would transgress some kind of peremptory norm? In that instance, who's supposed to yield in the circle? But in the context of immunity, we're not talking about that. We're talking about perhaps a later point in time where someone is trying to maybe bring a case against the motorist. And there, to the extent that that motorist does have an immunity, upholding that immunity does not result in the failure to yield in the circle. It doesn't transgress the norm. And I think the court has also made this clear in the Democratic Republic of the Congo case versus Rwanda, where the DRC says, we think that you, Rwanda, violated jus cogens, therefore there is jurisdiction in the International Court of Justice. And the court says, these are two totally different things. You know, you can't transgress the jus cogens norm, but that norm does not have the effect of knocking down immunities, creating jurisdiction in a court, and so on. That's not what jus cogens is all about. But if I can, Mr. President,
I was going to say, I believe what they said in the DRC case was that jus cogens does not create jurisdiction that doesn't exist.
Correct.
And that's something else.
Yes, and I was just using that to highlight another example of how jus cogens doesn't do something. It might be nice to have jurisdiction in the ICJ to vindicate a jus cogens claim, but that's not what is happening. And likewise, it might be nice to lift the immunity in order to vindicate a jus cogens claim, but that's not what it's all about. But if I could go on, Mr. President, just because the prosecution once again has returned to the International Law Commission, and I just wanted to make it completely clear to the court what has happened and what hasn't happened at the ILC, and I can do this fairly.
I think we can notice that the ILC is heavily tilted on that side, on the left side of the courtroom.
We are, of course, speaking in our capacities as representatives of either Jordan or the African Union, Mr. President. But let me just note that the Commission has, for several years, been working on the topic immunity of state officials from foreign criminal jurisdiction. So it's very clearly on point to some of the issues being discussed here. In that topic, in 2013 and 2014, the Commission unanimously decided that there's a category of immunity ratione personae and that it is absolute. There was no disagreement on the commission. What does that mean? It covers a head of state, head of government, foreign minister. It gives them complete immunity for either their public or their private acts while they're in office, and whether those acts occurred before they took office or while they were in office. No disagreement of any kind about there being exceptions to that, including in the context of arresting someone in a national jurisdiction for submission to an international court. Absolute immunity. The prosecution...
Was that specifically discussed?
Yes.
Arresting for purposes of transfer to an international court.
If I can go on.
All right, go on.
We then proceeded to discuss, are there exceptions to immunity? And the only proposal put forward by the special rapporteur relates to exceptions to immunity ratione materiae. In that context, the special rapporteur proposed maybe there's an exception for immunity ratione materiae, not head of state immunity, in the context of surrender to an international court. And in that context, the International Law Commission, without any significant disagreement, set aside that exception. Now, there were other exceptions that generated considerable disagreement, but all of that is in the box of immunity ratione materiae. None of it relates to the 2013-14 discussions about head of state immunity. On that, the Commission is absolutely clear, as I think Professor O'Keefe indicated, and governments in the Sixth Committee receiving our reports in 2013 and 2014 reacted very positively to that across the board. So there really is no disagreement about this in the context of immunity ratione personae.
Thank you very much. Mr. Kreis? Now, I think after your speech, we will have to rise for lunch.
Yes. Mr. President, I wanted to respond to your two specific questions. But before doing this, allow me an immediate response to what my distinguished colleague Sean Murphy has just said, because I think it is really important. One of the very crucial questions before us is whether the arrest and surrender of a sitting head of state for the purposes of international criminal proceedings falls within the immunity rule ratione personae on foreign criminal proceedings the ILC is dealing with right now. I'm not privy, of course, to conversations that ILC members may have among themselves, but I have written the materials closely. And I have not been able to detect during all these years anything close to a discussion of this specific limited issue, let alone anything in the current texts that would settle that question. And therefore, I humbly ask if this is a proposition which is in the room, that we are referred to this specific language that I understood is somewhere present in the documents. I have not detected it.
And just so the record is clear, when you say specific situation,
Absolutely.
you mean in terms of before an international
Absolutely.
Criminal court.
Now, on your two questions, Mr. President, I will keep it brief in recognition of the time. You have referred us to two quotes, and you have invited us to ask ourselves to reflect whether this can be of help to our important considerations. I have understood your question not to imply that the appeals chamber can derive a solution from simply applying those broad principles. You have asked us in the manner of, is that food for thought which is useful for deliberation? And my answer is yes.
You perfectly understood the part of the question, yes.
Thank you, sir. Let me start with a second quote from Barcelona Traction.
And you say the answer to I interrupted you. You say the answer to the question, generally speaking, is what?
Well, I'm just trying to give it. Let me start with what the Barcelona Traction, or in how the Barcelona Traction quote is important to our case. For me, the most important part of your citation is the words, there are obligations of states vis-à-vis the international community. And I cannot emphasize it enough that this is part not of a scholarly treatise of some creative, fancy scholar. This is in a judgment, not even a minority or dissenting opinion. This is in a judgment of the International Criminal Court. What does it mean? It does mean the recognition by this court, the International Court of Justice, that there exists an international community to which states have, under customary international law, obligations. And this is very important, I would suggest, to the question on, and that's a very fundamental question, on what the jurisdiction of this court is based. And it was a little bit implicit in the question raised by Judge Harrison a minute ago, to which I would respond, I have just responded, it does not exhaust the matter. If there are obligations of states vis-à-vis the international community as a point of reference, there may also be, and I would argue there is, a jus puniendi residing in this international community, which transcends states. This is at the very essence of this entire enterprise. And my argument, which I have developed, and I shall keep it brief in the written observations, is that this has consequences. And from that it follows that just to conceive of the International Criminal Court as the result of delegation of national powers does not exhaust the matter. I just wanted to allude to the fact that this is not fanciful speculation, but that we have ICJ jurisprudence endorsing the core idea. On the joint opinion by the Honorable Judges Higgins and others, here I think the core point helpful for our considerations is to be a little careful with the assumption that the value of international stability, stability of the international relation, you can phrase it in different words, invariably, imperatively requires to grant immunities in all circumstances, full stop. We all agree here that as a matter of current international law, there is absolute immunity ratione personae for national criminal proceedings. We are in disagreement how far this rule applies, but we are in agreement. So we can say currently states are of the opinion, that's the underpinning value, that there is too much of a danger to international stability to allow for an exception from immunity ratione personae in national criminal proceedings. But what this phrase suggests, that may not be the full story, to quote. It may be that the very purpose for states coming together and establishing an international criminal court is that this is an instrument, so to speak, to change the risk calculus. The only thing in the speech of my distinguished colleague and friend Roger O'Kee that I did not enjoy, otherwise I enjoyed it thoroughly, even though I profoundly disagree. But the only thing I didn't enjoy was that he seemed to interpret me as, so to speak, taking offense at the presumption of innocence. I'm not just a public international lawyer, I am a criminal lawyer too. The presumption of innocence, for the record, is sacred. And this, Mr. President, this is what is behind the immunity rule. Just because we do not know at the start of criminal proceedings whether the person concerned, the sitting head of state, is guilty or not, therefore we must be so sensitive to possible abuses, possible misconduct of proceedings, especially in cases which are politically so sensitive, like the ones against sitting head of states. But now the calculus, this risk calculus, which is behind the immunity rules, it changes, I would argue, fundamentally when states have come together to establish an international criminal court. And we have negotiated for years to shield this international criminal court against the danger of political abuse and so forth. Here, and one thing cannot be disputed, more than 100 states, state parties, have come to the conclusion that the stability of international relations between them is not jeopardized if there is an exception from immunity ratione personae. And I would argue just because they trust this international criminal court. And therefore, and this is in line with this statement you have helpfully referred us to, the question mark which these honorable judges place before us might be the risk calculus before international criminal courts of this nature here be different than in national criminal proceedings. And my suggestion is this includes vertical cooperation with this court. Thank you, Mr. President.
Thank you very much. And perhaps one might add to that, this international court, arrest warrants also and indictments need to be confirmed by judges, not just the prosecutor. We can leave it at that for now and come back at 2:40. At 2:40 and resume our sittings. The court will rise.
All rise.